I think we're all set.
Great, thank you. So good afternoon, everyone. This is the December 13th and final meeting of the Criminal Records
I think we're
Review
all set.
Committee. So good afternoon, everyone. Ooh, I have an echo. Is it echoing for other people? No? Okay, it seems to be better now. Thank you. Hopefully that corrects itself. Bob, did you have a question or you just?
I'm trying to figure out how to change my name on the settings. That's all. I'll
Okay.
figure.
All right. Thank you. So we are here for our final meeting to do some more information gathering and then to do some votes. Hopefully people have received and had a chance to review information that Jane has been sending us between the last meeting and this. Before we get started on the agenda, does anyone have any questions? So as you may be able to tell, I'm at the tail end of a cold here. And so I may start losing my voice. And if I do, my very talented co-chair, Representative Talbot Ross, I will ask you to take over. We'll just kind of see how it goes. I'm okay if I'm not talking, but if I end up having to do a lot of talking, I may need to have you take over. And yes, it is a cold. I did test. And so, all right. So diving into our agenda, we have some requested information that is being provided to us first from Ann Jordan from the Judicial Branch on Class C crimes and reasons for denials of motions for restricted access under the pilot project, which I know, Ann, you did send us some materials, but if you wanted to present those or summarize, that would be great. Thank you.
Sure. I presented to the committee the lists of actually Class C, Class D, and Class E crimes that are all active in MEJUS. What that means is those are crimes for which the law is currently in effect and has an assigned sequence number. You will see on the right-hand side of the charts, there is a listing of the number of times that particular crime has been charged in the last 10 years. Surprisingly, I think we've discussed this real briefly, well over 48% of the Class D and E crimes have never been charged. As to the reasons for the dismissals, as the committee may recall, there had been a pilot project allowing persons who had committed a Class E crime before the age of 21 to file a petition to seal their records. I had previously provided the committee a chart broken down by court or prosecution district and by year of the number of cases that there was a motion to seal and the results. I understand I had to leave the meeting last week, but I got an email from Jane saying the committee would like to know the reasons why motions to seal were denied, and I provided that information to you from MEJUS this morning. The reasons varied from the motion was filed after the law expired and the court had no authority or jurisdiction to hear the motion. The petitioner had more than one criminal conviction. We had one case where the petitioner failed to appear at the hearing. That motion was dismissed without prejudice, which means that the individual could have filed it again for consideration by the court. The crime was a Class B, C, or D offense or was a civil violation. We had one petition was for a civil violation and illegal possession of alcohol by a minor. Others that were B, C, or Ds, burglaries, a lot of Class D assaults, violation of PFA orders, and Class C, most of them were driving offenses. We had 12 people under that. 4 people had filed their petition before waiting 4 years before filing for sealing. The shortest time period was 10 days after conviction. And we had 2 cases where we could not determine from the Megis docket sheet, excuse me, the reason for denial. When I had that, what I would do is I would go into Megis and check to see if they had any other criminal convictions. In both of those cases, they did not. But I was unable to get from the written docket records the reason for those denials. We have 3 more petitions that were filed in 2020 pending in the York County criminal docket. They're scheduled for contested hearing in January, and the DA's office does object to those petitions. 2 were withdrawn by the petitioner, and Megis only said withdrawn, and 1 file has no action taken. And that's what I can provide the committee.
Thank you. And any questions from committee members? Seeing none, thank you. That was very helpful. Next, I'm going to hear again from Matthew Ruel from the Maine State Police, State Bureau of Identification, information regarding convictions for possession of marijuana, whether the criminal history record of the conviction shows the drug was marijuana and the amount, and can criminal history record information that has been sealed be later released by SBI or the FBI.
Sure, thanks for having me again. This will be really pretty quick. It's kind of what I've said before and kind of explained. It's really complicated to try to get at any marijuana convictions just because of the way that they're classified within the systems. So generally all marijuana convictions are tied into a schedule. They're classified as a Schedule Z drug. So if we were going to do some kind of a query from within the database, you would generally have everything come back with the Schedule Z, and you wouldn't exactly know what type of drug it was without going and digging into the records to really glean that information from it. So there would be a lot of manual labor to try to get at that. That doesn't mean that we couldn't identify a very small amount of cases, probably prior to 1976. But anything after that date, it definitely would be a lot of manual labor. And nothing on the amount without going into all of those cases and reading through charging documents to try to find out exactly what they were charged with. The next question that I had was, can criminal history record information that's been sealed later be released by SBI or the FBI? So that's the thing about sealing the record. Many of the states that we've kind of reviewed what they're doing for sealing has to do with sealing the record from the public's view, but it's available to law enforcement. And then some of those other states we've looked at, if there's new criminal conduct, you could go back and toggle that back to be disseminated to the public, or you could make the records available for certain requirements, like if it was foster care, adoptions, things that had a statute that allowed that information to be disseminated. So sealing it is generally, if you're going to seal it, be from the public side, but then you can toggle that back and forth with some changes to the database. So it would just be a matter of how we establish things in the statute. And that's really it for me.
All right. Thank you, Matthew.
Sure.
Yeah. I mean, the way I understand it, and correct me if I'm wrong, but in general, sealing in Maine would mean then the record becomes confidential. And
Correct.
to the difference between confidential and public. So sealing, really what we're doing by sealing is not sealing them, we're making them confidential.
Yes. Yeah. And sealing is just the word we'll use for it to prevent it from going out to the public. Right.
Right. All right.
Good. Thank you.
Any questions from committee members for Matthew? I'm not seeing any. Now we're going to hear from our esteemed analyst, Jane Orberton, information about rehabilitation certificates and then laws on unsealing convictions in Maine and proposed chapter and in Massachusetts, and legal requirements and process for unsealing in Massachusetts. Oops, and did you have a question before we get
I
started?
just wanted to tell the committee that the Schedule Z drugs is defined that Matthew just talked about is in 17A, section 1102 sub 4. So you get your full list of Schedule Z drugs there. That's all.
All right, thank you.
All set?
All set, Jane.
Okay. I sent you a memo last week that contains all this information. So if there's, I will only go over it in brief. If there's more you want, take a look at the memo and see if it provides what you need, or give me a call or send me an email. There are various types of rehabilitation certificates. They've been used in other states to restore the right to vote or to hold public office, to prohibit discrimination in occupational and professional licensure, in hiring, in housing, for extension of credit, for access to insurance, and for access to education. Some of those certificate laws shield an employer or landlord or licensing board from liability if they employ, lease, or license the holder of the certificate. So all of the states have different purposes to their laws, and then they contain different things. Some of the certificates are issued by a pardon board. Some of them are actually available only to a person who has already been pardoned. So there are, I listed on the sheet a number of certificates. Alabama has something they call an order of limited relief. Colorado has an order of collateral relief. Connecticut, a certificate of rehabilitation. District of Columbia has a certificate of good standing. Hawaii has a certificate of discharge. Illinois has a certificate of relief from disabilities and a certificate of good conduct. Michigan has a certificate of employability. New York also uses the release or good conduct for their certificates. Ohio has what they call a certificate of achievement and a certificate of employability. Vermont has a certificate of restoration of rights. And Washington has a certificate of restoration of opportunity. So it really, what you call the certificate really depends on your purposes. I did, you asked for data on the effectiveness of certificates. I contacted Michael Hartman, who you recall came to either our second or third meeting from the National Conference of State Legislatures. He suggested the 50-state comparison from the Collateral Consequences Resource Center, if you're interested in in-depth information. He did say that these laws haven't been in effect for too long, and there's not a lot of study has been done of them. But there was a 2016 study of certificates issued by the courts in Ohio that found that individuals who'd been issued certificates were more likely to get an invitation for an interview than those without. So obviously that was an employment related one. And it also said that the rate at which they were got a call back for an interview was about, it said, not far removed was the actual language, not far removed from the callback rate for people without a criminal record. There was a 2017 study of Ohio, not with regard to, the first one was employability. This one was for rentals, and it had similar results, about the same callback as the general public. And what he says is going to be included in an NCSL report is, quote, "It is theorized that employers and landlords view certificates as both a sign of rehabilitation and a form of protection from negligence from liability. The rest will go much quicker. With regard to Maine's unsealing of convictions because of a later conviction, the pilot project had that provision for that. And the proposal in Chapter 310A that was in LD 1459 also has a method of extinguishing the right to the order of restricted dissemination because of a later conviction. You asked me about the legal requirements for unsealing in Pennsylvania and Massachusetts. Pennsylvania provides a process for vacating an order of limited access. If a person is convicted of a new misdemeanor or felony, that process is initiated by the prosecutor. And the only thing it mentioned in the law that I was reviewing was it doesn't apply if a record was sealed because it was a final disposition other than a conviction. We contacted the Office of the Commissioner of Probation in Massachusetts, which is the office that is in charge of sealing. And they said there is no provision in the Massachusetts law for reversing a sealing law on the grounds of reversing a sealing order on the grounds of a later conviction. That's all I have. Thank you.
Thank you, Jane. That's interesting information. Any questions from committee members for Jane on those pieces of information? Looks like Michael, did you have a question?
Yes, and I wanted also to thank Jane Overton for that information. Did you get a chance to look at copies of those studies from Ohio by any chance, the 2016 and 2017 ones?
No, I'm sorry, I didn't. That information came in from Michael Hartman on late Friday.
And I'm just happy to email him separately and ask him for that then, so don't worry about it.
Okay, thank you.
Yeah.
Great, thank you. Any other questions? Looks like Matthew.
Thank you.
Thank you. Jane, when you were going through the different states, were you able to tell whether the certificates were limited to a certain class of misdemeanors like we've been talking about, or did they apply to felonies and misdemeanors? Did you get any sense about that?
I would say both. Both.
Thank you.
Great. Any other question?
Madam Chair, I just had a quick question, and I may have missed it, admittedly. So, Jane, do we have copies of the actual criteria from the various certificates?
No. No, of course, it goes back in part to if they have a sealing law or an expungement law, what that law applies to. But I can put together some information for you.
The reason for my question, what I'm trying to tease out, is the fact that I know that a lot of folks, entities that are using evidence-based fill in the dot practice, folks who are using certificates, the way in which we look at risk assessments, the way we look at a lot of things in a standardized format, that standard has been set within a system that has generationally discriminated against, targeted, been prejudicial towards people of color. And so what I'm worried about with these certificates is that I just don't want to blindly consider a certificate of rehabilitation, just like I wouldn't blindly consider the use of risk assessment without diving in deep as to how they were created, what the criteria is that they include, and what value they assign to each criteria. Because these types of things can also have a very discriminatory impact. And I don't want to replicate that kind of a system when I think about the use of these certificates. Does that resonate with anyone? I just don't want to cookie. I want to know, and if this is like a recommendation of something that we really seriously are considering, we just have to do so with our eyes wide open, that these standardized processes of value, of evaluating a person's conduct has always leaned towards additional bias for people who look like me. So I don't know if that resonates with anyone, and I don't know where we're at in the discussion, but I did want to give that some voice. Thanks.
Thank you, Representative Talbot Ross. Yeah, I don't think that we've done a deep dive on these certificates. So I think those are all really good questions to ask. My sense is they're fairly new, and that from the information that Jane and NCSL has provided, that each state is approaching them in different ways, and that it really depends on what they're trying to accomplish by them. Again, it seems like some states are really focused on trying to minimize discrimination against housing. Others are really trying to minimize discrimination about employment opportunities by issuing these. And so they structure them based on that. But I agree that we don't know enough about these, and they are new, and we don't have information about, whether they're working the way they intended or not. I do find it interesting, this is the lawyer in me, that of course the giving some protection to landlords, to employers in terms of liability, it does seem to make some, just common sense that it would make employers and landlords more likely to rent and or give jobs if they feel that they have some protection against liability. So it seems like that's one of the focuses of some of the states. One comment I would also say is that Jane, just in a quick look at the different states that have some of these, it did seem like there were some states that had these certificates or some form of certificate that also had some sealing, expungement, clean slate statutes. Michigan jumps out, for example. So I don't think they're mutually exclusive. Is that accurate?
Correct.
Yeah.
Correct.
Yep. Michael, did you have a question or comment?
Yes, both, I guess, which is, I imagine them to be mutually exclusive, actually, because the certificate indicates to the person who gets the certificate that there's some underlying criminal record. Whereas if the criminal record's been sealed, then there should be no indication that there is a criminal record. So it feels to me like it's an either or maybe we have a desire to seal certain records and then allow for a certificate of rehabilitation system for another set of criminal records.
I think,
do you see my quandary? Yeah.
Yeah, no, I don't know that they're necessarily mutually exclusive, especially because you have that gap period in most sealing statutes. You have a time period. And so let's say someone's been imprisoned, for example, and so they get released from prison and they've got a time period before they can file their petition for sealing. Say that's 4 years. So what happens in that 4 years? Well, we know what happens. We've heard here, they face discrimination in employment, in housing, in perhaps professional licenses, depending on the state. And so I think that the certificates of rehabilitation can be issued more quickly. And some of course, in states that have like parole boards and pardon boards and stuff like that, they can be issued immediately upon release, which, yeah, so I don't think they're mutually exclusive necessarily. Obviously, it all depends on the structure. Yeah. Matthew, did you have another comment or question?
I did, but I was following up on what Michael just commented on. I didn't know if you were done or not, Michael, were you?
I was just going to say that Representative, Donna Bailey's response just now clarifies things, but I suppose they still strike me as mutually exclusive happening at the same time.
Yes.
So
yes, that makes sense. Yeah,
one
happening at the
defeats the
same
other.
time doesn't. Yeah, I agree.
Okay.
So to follow up, I looked just at Ohio. The study was hyperlinked in what was sent over, Michael. I had looked at Ohio, and it actually has a pretty generous, from our discussion at least, sealing statute in addition to the certificate. And the reason I asked Jane the question I did was because the impression I get is certificates of rehabilitation can be used for felonies. The study, for example, was looking at felony drug convictions, whereas the sealing statutes are typically limited to non-violent, non-felonies. So I think that these certificates are typically being used for people who can't get sealing and maybe won't be able to get a pardon because of a felony conviction, but who are looking for some kind of certificate. But that's why I asked about whether Jane saw the option for getting this kind of certificate with a felony. So I only looked at Ohio. I didn't look at others, but in that instance, it added up that way.
Thank you for pointing that out, Matthew. Foster.
Yes. Good afternoon, everyone. Just a quick comment. My view is that when we're dealing with certificates, it's almost like you're keeping a stigma and a bullseye in some form of discriminatory practice into the mix, into the issue. Because when people are released from prison, you're releasing them with a certificate saying that I just released from incarceration, I was incarcerated. And one of the things you want to try to move beyond is beyond the incarceration to put our lives back together. And if we're issuing certificates of employability or rehabilitation, we're in a sense giving the employers and those individuals who's housing an opportunity to discriminate. Because clearly, if you're going to take information that is from someone's criminal background and use that against them, then that's discriminatory. It doesn't matter if you're black or white. It's you're incarcerated, you're being released. It does affect those people of color more so than it does the people who don't look like me to a certain degree. So when we issue these certificates, are we giving the certificates more weight to someone who has just completed his GED or his HiSAT? Or are we giving it more weight to someone who just received his college degree while incarcerated? Because when you receive a college degree, it doesn't say that I was incarcerated. It says that I have a bachelor's or associate's or a master's. So I think we're then violating Title VII of the Civil Rights Act when we issue these certificates of probabilities, because now you're giving the employer, like I said earlier, an opportunity to discriminate, which is hard to prove that an employer did not hire someone based on his past criminal history. And if a person has to wait 4 years to have a record sealed or expunged, then that falls into the line of the data that the Department of Corrections has collected that people reoffend within the first 3 years. So we're dealing with issue that we have these conundrums that I think we're piling on by bringing in certificates of probabilities, certificate of employability and certificate of rehabilitation. I think that convolutes what we're trying to do here, from my opinion.
Thank you, Foster. Peter, you had a comment or a question?
Yeah, I just wanted to reiterate the point that I see the certificates as a way of dealing with situations where you're not willing to have their record sealed. And so, for instance, somebody released from prison with a felony record, we haven't been talking about sealing. I have, but nobody else has been talking about making those confidential. And if the records aren't confidential, then having a certificate is another possibility to enhance the employability and housing situation of a person. So I don't see them as exclusive. I would love to see them as exclusive, as mutually exclusive, but that's only if we're willing to make all criminal records confidential.
Thank you, Peter.
And I really don't expect that we are. I just have to maintain that position. I wouldn't want to give that up.
Your position is understood. Any other questions or comments on this subject? Or are we ready to move on? I'm not seeing any hands. So that brings us back to considering the two motions that we tabled last meeting. And I think that at least just from looking at the agenda, that both committee members who made those motions have kind of clarified the language. The first one is in regards to a constitutional resolution, and I think that was Representative Harnett. And so I'm going to call on Representative Harnett to just clarify the actual language of your motion. My recollection is you were going to work on that with Peggy and Jane.
Indeed. Thank you, Chair Senator Bailey. Last Wednesday, Michael, Peggy, and I worked together to try to clarify the motion that I attempted to put forward a week ago on Monday. And I guess just for process, should I ask for the motion to be taken off the table so that we can discuss it, or should I just
You
go
can
with
do
it?
that, sure, yes.
Sure. So I would move that we take the motion off the table regarding proposing a change to the Constitution.
Thank you. Is there a second?
Second.
All right, so it's been moved and seconded. All those in favor of taking the constitutional resolution motion off the table, just raise your hand. Jane, whenever you have it, just let us know.
I think we're all set. Thank
All
you.
right. Thank you. Thank you, Representative Harnett, for that. So go ahead and proceed.
Thank you. So what we first did was try to just restructure the most general motion that we could make to move this forward. And that would read as follows. The motion would be to recommend that the legislature pass and send to the people for approval an amendment to the Maine Constitution that grants the legislature the same authority the governor already has under Article 5, Part 1st, Section 11, to grant reprieves, pardons, and commutations. That would set forth exactly what we want to do. The other thing that we did in the event that the committee, and I don't think this is necessary, but it's not my call, wanted more precise information, is we drafted language that would amend that section of the Constitution that currently gives the governor exclusive power. And that would be done by simply adding the words "and the legislature" after the reference to the governor. And I'll read what that would read in total. It would say under Section 11, power to pardon and remit penalties, etc. conditions, the governor and the legislature, that's the new language, shall have power to remit after conviction all forfeitures and penalties and to grant reprieves, commutations, and pardons, except in cases of impeachment upon such conditions as would end with such restrictions and limitations as may be deemed proper, subject to such regulations as may be provided by law relative to the manner of applying for pardons. Such power to grant reprieves, commutations, and pardons shall include offenses of juvenile delinquency. So that is what, if the committee wanted the language that would change in the Constitution, that would be it. Lastly, if the committee wanted to actually amend section 11, but also add parallel concept in the Constitution to the part that applies to the legislature, we would add the language that I just read as section 24 to Article 4, Part 3rd, and that's the legislative powers. I'm happy to answer any questions. Again, the goal of this would be to provide someone other than the executive, in this case, the legislative branch, the ability to enact legislation regarding this type of criminal justice reform. And without it, the legislature might be stymied in order to accomplish what it wants to. So I'm happy to answer any questions, and then I would make the first motion and not the subsequent two, depending on how the committee feels. Does that all make sense?
It does, thank you. So I guess first, do committee members have any questions as far as clarification of the different options, if you will, and what Representative Harnett is proposing to do?
Madam Chair, I just want to find out, is this written down anywhere for us to look at the specific language? It's great work, thank you. I do
not
mind
have
seeing it written down in somewhere.
I don't
Okay.
have the ability to share it. Peggy, can you share the email that you sent to Michael and I last Wednesday afternoon? That's where the language appears.
I don't know if other committee members would just like to see the language and read it before because it's great work, but I'm a learner. I need to see it as well.
I don't have the technical skills to do so, but Peggy looks like she's working on it.
Okay, well, I think what I can do first is I can share this screen, which is there it is. So this is the main Constitution in Article 5, Part 1st, Executive Power, Section 11. And this is kind of the focus. We're not looking at the separation of power provisions in Article 3, but this is the executive power. And the idea is to put it right in here. So it would say the governor and the legislature shall have power. Unfortunately, this is a PDF, so I can't edit it, I don't think. Nope. And I'm going to stop sharing so I can look for the email that I think has all three of those options in it.
This was about 3 o'clock in the afternoon last Wednesday.
Thank you.
That helps narrow it down a little bit.
Senator, this is Jane.
Yes.
Could I just ask Representative Harnett, Representative Harnett, are you proposing right now that the committee focus its discussion on the much shorter motion option and not on the statute and not on the constitutional provisions?
That is my suggestion, though. I did just want to show what those constitutional changes might look like. But I think the cleanest way would be the shorter motion.
All right. Peter, did you have a question?
Well, that was going to be my suggestion, that the motion that's in our agenda be the one that we vote on rather than trying to figure out specific language.
Thank you. Michael?
Thank you, Senator Bailey. I have the language ready if you want. I can share my screen and display it.
Just before Michael does that, Peter, the language in the agenda is not the language that I'm proposing. It is a simpler version, but it's not that precise language.
Okay, sorry. Then I really got confused.
Right. So Jane or Peggy, can you help Michael to be able to share his screen?
Can you share it, Michael? If not, I have it and I can share. There he goes.
So this is what Representative Harnett was talking about. This underlined portion, 3 words, and the legislature. And then if there's a desire to add this entire section to the part of the Constitution that grants powers to the legislature, then this was Peggy's suggestion, I believe, to just export this entire section to Article 4, which is the part that comes right before the part that grants executive powers.
Michael, can you scroll up to the simplified motion that was above that? Because that's the one that I
Here
would
it
be
is.
moving. Okay.
This.
I don't know about anybody else, but that's jumping all around on my screen.
No, it's not on mine, and I can read it out loud. The motion would be to recommend that the legislature pass and send to the people for approval an amendment to the Maine Constitution that grants the legislature the same authority the governor already has under Article 5, Part 1st, Section 11, to grant reprieves, pardons, and commutations.
Thank you, Chair Bailey, and that is the motion that I'd like to make.
And is there a second of that motion?
I second.
Seconded by Representative Talbot Ross. So now we'll have discussion on that motion. And Judy, you have your hand raised?
I do. So the governor's authority to do this is exercised through the pardon board process, but that is not what we're talking about here. We're talking about allowing the legislature to pass laws. So does this motion say that it's the same? This is just confusing because her power is vested in the pardon board. She approves and signs, but we're not asking for that. But this could be construed for that. We're not suggesting the legislature hold hearings and grant pardons one at a time. I just find this very confusing.
I don't think that was ever the intent of the committee, and it certainly wasn't my intent. I don't envision people coming to the legislature seeking pardons. The concern has been due to the decision in, I believe it's State versus Hunter, that statute, that the governor's power has been read to preclude the legislature from doing anything with regards to commutations, sealings, etc. And this is to overcome that decision by giving the legislature, the legislative branch of government, the equivalent power that the governor has under Article 5, Part 1st, Section 11.
Okay, and
the governor does not have to take the advice of the pardon board. It's the governor's exclusive decision. She does not. She's been read as the only person, not she. The office of the governor is the only office that can grant pardons, commutations, etc.
okay. So there's plenty of lawyers on this call, and I am not among them. But will this do the trick? Do we have a ruling that says this will do the trick?
I don't think we do. I think that's what we're trying to accomplish, and I would hope that it does that. It would allow the legislature to act in a legislative fashion to address these types of issues. That's my intent and hope.
Yeah, the intention would be to, by a constitutional amendment, overcome the obstacles of the Hunter decision. So the next hand I saw was Laura's.
So I thank you, Senator Bailey. I have a couple questions. First, I think I agree with Representative Harnett that you may not want to get to the specific drafting of the language for the Constitution, because I'm not sure, and I'm not a constitutional scholar, I'm afraid, but I'm not sure that you can address concurrent powers within the individual articles that outline the powers of each individual branch. And then my second question goes to how practically would it work if both the legislature and the governor have concurrent powers in the Constitution? There's nothing to prevent any future legislature from taking any action with respect to deciding that it does want to issue pardons. And if it chose to do that, and you've got two branches of government working with that pardon power, how are you going to set that system up? Are we setting up conflicts? Can a person go from one forum to the next if they don't get the response that they like? I'm just not sure what is contemplated or what the fallout down the line would be of vesting concurrent power in each branch. And I wonder whether it upsets the balance of power. Now, this is a different issue from separation of powers, but does it upset the balance of power contemplated by the state and federal constitutions, where one branch makes the laws, one branch enforces and can forgive violations that have been found in the third branch, the judicial branch? And I'm sorry, I don't have answers to any of those questions, but those are some of the issues that this language is bringing to my mind.
Thank you, Laura. Our next are Matthew.
Thank you. I am very, very far from a constitutional scholar, but the first question I had was answered that this was done because of that Hunter opinion. I apologize because I missed our last meeting, so maybe we talked about this, but I know the meeting before we had discussed whether it would be kind of a lower hurdle to just pass an expungement law, which I assume is why the constitutional amendment's being considered, and then wait for an appeal and deal with an appeal than it would be to try to amend the Constitution. So I didn't know if maybe a decision was made, and for some reason we thought this was the cleaner route, because it just looks to me like the much messier route. But again, not really my area of expertise by any means.
Thank you. Are committee members okay if Michael stops sharing his screen, just so we can kind of see each other as we have this discussion? Thank you. So further discussion, questions, comments? I think I saw Foster raise his hands before my boxes shifted around. So Foster, go ahead.
Yes, well, this is dealing with the Constitution here is a difficult issue. I researched as many states I could find as far as the separation of power. And I try to stay close to the New England area, so I look mostly at Massachusetts, Vermont, New Hampshire, and Connecticut, and Rhode Island. Our Constitution, as far as the executive branch, is not too far off. The language is pretty much similar. And as I looked at how they passed some of their expungement laws and some of their good time statutes and stuff like that, they didn't have these complications. It's the interpretation in Hunter that set forth this conversation now. It's the interpretation of how we want to interpret the executive powers in the branches. because commutation is clearly a reduction of sentence. Expungement is not a reduction of sentence, and sealing a record is not a pardon, it's not a commutation. So we have to look at the interpretation in Hunter, in my opinion, look at interpretation in Hunter to gather a better understanding. How do we arrive at this point where we have to go in and change some of the language to the Constitution? I think that where the Constitution clearly says that you can't have one branch with dual powers, that poses another problem. If we're going to have the legislator infringing upon the executive branches and sharing those particular duties as one, I believe that may propose more problems later on down the line. So my thought process has been, if we can come up with language that will separate what we're trying to do from the commutation and the pardon and the reprieves, because we're not asking for an expunged record to exonerate misconduct or the crime that was committed. We're not asking for a sealed record to be considered a commutation. We're just basically saying that records that are sealed are confidential. And that, in turn, should not infringe upon the executive powers. Massachusetts has passed their law. Connecticut has passed similar laws. Even Texas has passed expungement and sealed record laws, and that didn't infringe upon their separation of powers and the governor's separation of power. It hasn't done so. So why is it necessary that we have a reform bill that helps those who are incarcerated put their lives back together, come up with this complication of dealing with the executive branch's power? I think that there might be a better avenue with language. I think we can institute something language that will allow the legislative and judicial branch to move forward without infringing upon the governor's separation of power.
Thank you, Foster. I think that points out the dilemma with the Hunter decision, and although, yes, the legislature can clearly do sealing statutes, we've done it already and could do that going forward, we're kind of limited to that. So the hurdle is, given the Hunter decision, how do we give the legislature the clear authority to be able to consider anything beyond sealing? And if we're comfortable with just sealing and that, we don't ever want to consider or look at expungement, then, we don't need to do anything. But if we want to at least have expungement on the table, how do we accomplish that given the Hunter decision? So Michael's got an answer to that.
I think I do, Senator Bailey, and it's in part to reiterate what Laura Eustack said, which is I think that we should leave drafting to OPLA. And to answer some of Laura Eustack's other concerns, and a concern that was also voiced by the Maine Press Association,
Judy Meyer.
Judy Meyer. I think that it might behoove us to make the motion more general rather than specific to the section of the Constitution that grants the pardon power to the governor. And so something like, the motion, as I think about it now, would be something like to recommend that the legislature pass a piece of legislation that allows the legislature the capacity to pass laws to expunge criminal records that will survive constitutional scrutiny, or something along those lines, so that the drafters of the bill have more leeway around how to overcome this problem. And so that means that we don't have to craft the language here. We don't have to get entangled with the constitutional issues. We don't have to get entangled with the issue of a form shopping person who goes to the governor and then the legislature to have their criminal record expunged or pardoned or commuted. So I'm curious what the group thinks about a broader motion that just puts it in the hands of the drafters of legislation about how to solve this problem and give the legislature the power to pass expungement laws that will be found constitutional.
Peggy, did you have a response to that?
Yeah, I would like to think that a motion like that is doing is actually directing the Judiciary Committee to work on that rather than Jane and me and my colleagues. But what you're doing as a study committee is making a recommendation. That recommendation goes to the Judiciary Committee. The Judiciary Committee can work with whomever they want to figure out what they want to do next with that recommendation. So it wouldn't really be asking OPLA to draft it so much as we would be helping the Judiciary Committee go forward with whether it was a constitutional resolution or if they were satisfied with some other statutory change.
Yeah, I mean, I'm thinking something along the lines of, again, what I just said, which is to recommend that the legislature draft legislation to overcome the obstacles presented by State versus Hunter to allow expungement of records or something like that. I mean, that's what we're really trying to do, right? Is we want to overturn State versus Hunter and give the legislature broader authority in looking at records, criminal records, in terms of sealing and expungement, vacation, all those sorts of things. So let's just, just try to, state what we're trying to do. I agree, Michael, not necessarily spelling out the exact process to get there, because that needs to be hammered out, like Peggy said, in the Judiciary Committee. Representative Harnett, this is your motion. So what are you thinking?
Well, I'm thinking, like everybody else has thought, that I'm not a constitutional scholar either. So avoiding that issue completely makes me feel more comfortable. But I'm brought back to the discussion that we had maybe 2 meetings ago. And I don't read Hunter as broadly as I don't read it as this blanket ban on what the legislature can and cannot do. It's a specific case about what a court was doing, revisiting sentencing. But the discussion turned towards what is the difference between expungement and commutation and pardon? And are we going to be barred by Hunter because expungement is more like a pardon than it is not? If we think we can open, and we started with just doing a statute, then the concern was, well, if we did the statute and it's challenged and it's found unconstitutional, we're back to square one and would have to then draft a constitutional amendment. If there is a path, a viable path to overcome what you call the obstacle or challenges presented by Hunter, by giving the legislature the power to deal with things like expungement through legislation, I would be comfortable with that as well. I think we're all trying to accomplish the same end. It's how do we get to that end, and what is the simplest and cleanest way to do so? And I'm happy to make the motion that gets us to that point.
Yeah, and I think that's why I was focusing on, then let's just talk about the end and let the process details be worked out in the Judiciary Committee.
Okay.
And next have Judy Meyer.
Thank you. So again, I'm trying not to be dense here, but so in the Gary Hunter case, he was asking, or the DOC asked that he be released from prison early. The very specific case because of good behavior, that is not at all what we're talking about. And I just do not understand the comparison to sealing records 4 years after a conviction has been satisfied with a single case of a inmate being released from prison. I just don't see a parallel here at all. But again, I'm not an attorney. I just don't see it.
I think we're trying to go beyond just sealing here. Isn't that correct? We're trying to get to, we have done sealing of records, and that has not been successfully challenged as unconstitutional. But we're thinking about doing something in addition to just sealing when we're talking about things like expungement. Am I correct there?
I believe you're correct, that that's what this discussion has been about. Are other committee members confused as to where we're at? We should take a temperature check here. Representative Pickett?
Yes, thank you, Madam Chair. I think I've been listening to all of this, and I think that Mr. Bates was very articulate in describing what we're trying to do and what some of the stuff we're talking about, how that can, instead of really intertwining together and helping, could possibly rile the waters up a little bit and not allow us to be able to get to where we started out originally in the committee, to be able to come up with a resolution to people being able to get on with their life after they get out of prison, to be able to reduce the stigma, reduce the obstacles that come with housing, with employability, and all of those things that we're trying to do. But I think if we put too many things on the table here and stuff, and we do that, I think we get into an area where, I don't know about you, but when it comes to amending the Constitution, whether it's the state constitution or not, I think that that's a very serious issue when you start amending the Constitution. And I think that we really, in my opinion, I think we should stay focused on what we've been trying to do. They're talking about sealing, expungement. We've talked about certificates, all of these other things, and really find ourselves a pathway to go forward that is going to garner the support needed to be able to make it a reality in people's lives. Thank you.
So how about just recommending that the legislature be granted or be allowed, I'm not sure of the word, the power to expunge criminal records despite the holding in State versus Hunter? Again, that's what we're trying to get at, is that let's do whatever we need to do to ensure that the legislature has the authority to consider legislation for expunging criminal records. So I throw that out there for discussion. Marissa.
I just wanted to clarify. So are we still talking expungement using the definition that means the records are destroyed or cleared out completely?
Yes.
I would just chime in, with perspective from the broadcast industry after talking to some of my colleagues and other members in broadcast, that I think expungement under that definition is just not something we can support. We generally believe in open records and, the public having that access. So I think sealing with some language tweaked in 1459 is something we could support, but expungement, after talking to folks, is just not something that we can support.
Thank you. Further discussion. Representative Talbot Ross.
Yeah, I just wanted to clarify. I don't think that we're asking this committee to support or not support expungement. I thought that the question was whether we're going to recommend that the legislature as a body is able and has the authority to consider putting that forward. We seem to get to this place each time when we're talking about this, which is the committee actually thinks that we're trying to vote on whether or not we believe there should be a constitutional. That's not what we're asking for. This is a recommendation as part of a report that goes to the Judiciary Committee, in which we're saying we support the legislature considering this pathway, opening up this pathway to consider it. Does that make sense to folks? We're not asking you to vote on whether or not you believe that the legislature have the power to do that, to expunge. It's hard when the whole screen is blank faces. So I'm just trying to get some feedback here, y'all. We really need to be very, very specific in the way that we continue to discuss this, so that we don't keep conflating the two. And I keep feeling like we're conflating the two. Thank you.
Thank you. Elizabeth?
Yeah, so I feel like the motion, or the draft motion that Representative Bailey made it a little bit easier for me. But now Representative Talbot Ross's comments might complicate it. So let me just tell you where we are, which is I don't have the consensus of my members on a constitutional change, but because we have supported expungement in the past for trafficking victims, I do have their support for expungement. And so I'm trying to figure out, like, given the various emotions, what I can support and what I can't. And maybe it just means I just, I don't vote, which is fine too. But just that's what I'm grappling with in my head. That's so.
Thank you, Elizabeth. Further questions, comments, Laura?
When people are using the term expungement, is that intended to mean that, and I understand that it means records would not just be confidential, but that they'd be destroyed and people would be authorized to say they haven't been convicted. Is that right so far?
Mm-hmm.
Does it also mean that those records would no longer be available to the courts or to law enforcement for criminal justice purposes?
I think that those would be questions that would be answered when and if there was ever any legislation proposed to expunge records. Again, we're not discussing here what records should be expunged, when they should be expunged, how they should be expunged, who would have access to those records if they're expunged. This discussion is just about, again, trying to make a recommendations to overcome State versus Hunter, so that the legislature could consider, if a bill was put forward, expungement of records. Which I think the consensus is that the majority of people are not confident in doing that now. And so we are limited in only looking at sealing. That's my understanding. Does that help more? Further questions, comments? Jane.
Yeah, I'm going to go out on a little bit of a limb here. Does it help to think about the constitutional resolution question as you're having two options? Well, of course, there's a third one, which is you don't do anything. But one option would be that you recommend that the legislature pass and send to the people for approval an amendment. That is Representative Harnett's proposal. It seems to me there's another option, maybe nobody's interested in this one, but that would be to move to recommend to the Judiciary Committee that they review options and report out legislation to address the Hunter problem. So that, in all honesty, is not as strong a position as Representative Harnett proposed, which was recommending passage of a solution. But I didn't know if that might help you. Thank you.
I'll speak for myself. I like that second option, except that I think we have to somewhat define when you say the Hunter problem, you know.
Well, yes,
what
I'm
is that-
sorry, that was
What does
kind
that
of
mean?
shorthand.
Yeah, but, and so as long as we can have a little bit of a definition of what the Hunter problem is, I'm fine with that second option. But further discussion, comments, reactions, Representative Harnett, where are you feeling? This is your motion.
I understand that. And magically, that language that Jane just read appeared on my other screen here. And it's, as she said, it's a motion to ask the Judiciary Committee to review options and report out legislation to address the separation of powers question raised in Hunter. But to address your concern, Senator Bailey, would that help to add language after that? So it would read, motion to ask the Judiciary Committee to review options and report out legislation to address the separation of power question raised in Hunter as it relates to expungement and other treatment of criminal records.
No, I don't think that's necessary. When Jane verbally gave that second option, she just said the Hunter problem. There was nothing about separation of powers. I think in the version you just read, the separation of powers is enough of a definition for me. But I don't know how other committee members feel if they want more, but I think that defines it in terms of what's the Hunter problem. Well, it's separation of powers issue.
Well, then in order to just keep the ball moving somewhat down the field, I will resubmit my motion to read a motion to ask the Judiciary Committee to review options and report out legislation to address the separation of powers questions raised in, and then we put in the citation for State versus Hunter.
All right, thank you. And I can't remember who seconded your motion.
I think it was either Rachel or Representative Talbot Ross or Mike.
It was Representative Talbot Ross. And Representative Talbot Ross, is that okay with you? That amendment to the motion? It is. Thank you. All right. And then I think, Matthew, you had your hand up. Are you all set? You took it down.
I guess I'll ask maybe what's the dumb question, because I think this is what Representative Ross was trying to clarify for people, but it didn't come across to me. Are we saying then that a sealing bill, if that was the ultimate outcome of this recommendation, would be satisfactory for people? Because that would certainly resolve the separation of powers issue, but it wouldn't result in an expungement bill. And that may be what you were getting to, Representative Talbot Ross, which is we're not supposed to be that specific. So if I'm missing that, that's fine by me, but I'd certainly imagine something that was looking specifically to expungement and not just resolving the separation issues, which could easily be resolved with a sealing bill. So I guess that's a question for you, Representative Talbot Ross, if you can follow the question.
Kind of, sort of. You're right around the pathway, but I think at this point, with the sealing, we would be able to get there. But I think at this point, my sense is everyone is so confused.
Yeah.
I'm not sure if we just really need to take a pause and go back to clarify. I mean, we've got 20-something people on in this meeting, and I'm not sure if everybody really understands what we're talking about here. So my quick answer to you is yes, but the question to the committee is, does everybody actually understand where we're at? And that's you've got a motion, it was seconded. This is discussion period. So that's my concern is if folks understand what we're trying to vote on. And I don't know, I don't know if Representative Harnett, if we're able to put the revised motion on a screen. Again, I'm just thinking about the listening public and also for committee members who are not engaged in this specific discussion right now that are just trying to keep up. So yes, Matthew, but we need to clarify where we're at.
So Representative Harnett, are you able to put?
I am unable to do almost anything that involves technology on my end, but I suspect that we have more skilled people here, and I see Peggy's already putting it up. And the only change I made to her language was I put an S on question. I just made it plural. And I'd hoped that this addressed Representative Talbot's Ross concern that we're asking for options to address the concerns that this committee has about the larger issue of making people who have been incarcerated able to live full and productive lives when that incarceration ends and when their debt to society has been paid, and that we want the Judiciary Committee to explore all of those options, but do so in light of the State versus Hunter case. And then again, the Judiciary Committee is the ultimate decider of what legislation would come out and be presented to the full body. Does that help, Representative Talbot Ross?
Yes, it does. This is going to be, yes, it does. I just wanted to also confuse things. No, is that the bill that we just put in to extend this committee's work will also have a nod towards this particular area of work.
Okay. Further questions, need for clarification, Peggy?
I don't want to muddy waters, but I do want to make sure, we talked about this in the very first meeting. We've never had a law court decision on anything other than sentencing, changing what somebody's sentence has been already imposed and they've already been serving it. That's what Hunter, that's what Bossy, that's what the third one is. And so we don't actually have the law court saying this is okay or this is not okay for the legislature to expunge records. We also don't know where the line, if expunging records is so close to being a pardon because it does away with the whole record of somebody's criminal convictions. Is that the same as a pardon? We don't know if the court would look at it that way, but that is why it's been raised as a question. We also don't know, although it wasn't challenged while we had the sealing law in place, even if the record is sealed, if the person whose record is sealed can say, I have no record of convictions, is that akin to a pardon, so that it would also run afoul of the separation of powers? So I think it looks like what you're talking about doing is asking the Judiciary Committee to explore all those options and look at those things more in depth and maybe get some more answers back. I would just be a little bit worried about saying, oh, we can do sealing. We know that's no problem. It's not a violation of the separation of powers. If you include the language that somebody can claim that they have no convictions. So we didn't have any challenges, so we don't know. But I just wanted to make sure that it was clear that we're not absolutely certain that sealing a record would be upheld under the whole line of on the Hunter line of cases.
Acknowledge, Peggy, that we can never be certain what the judicial branch and the law court is going to decide on anything. We make our best guesses, and we try to pass laws that are constitutional. But yes, ultimately, it's the law court that makes that decision. Representative Pickett.
Yes, thank you, Madam Chair. Just as a point, I know we're getting ready to go with this, but I want to make sure that we haven't lost sight of the fact either that it's only been a couple of months that the LD 1167, the Act relating to fair chance in employment, has come out. So, that we don't really know exactly how that is going to play out and how that is going to help out in the employment part. And I've read that LD and that law in detail, and it does do I think a lot of the things we're trying to help people with right now. And then the fact that the Department of Professional and Financial Regulation, when Nan Head was here, and how she explained that they're the leader in second chances and stuff, and they do a lot of good work there. Just to point those out, that there are some good things that are happening right now trying to deal with this issue, and hopefully we can come up with something that will kind of bring that all together and maybe even enhance that. But I just throw that out for point of information.
Thank you, Representative Pickett. Jonathan.
I lowered my hand and didn't unmute myself. So I just wanted to mention that although I sent an email earlier saying that we did not have an opportunity to vote on this as the MPA, I will be abstaining from this, but I did just want to mention that I can say that there's at least some DA support with regards to this ideal of relooking at somebody's convictions in the past and looking at a process that actually would allow an opportunity to, I don't know what terminology we want to use, because I know they're all kind of explosive language that could mean something to somebody else. But as Elizabeth pointed out, I've gone on record with support of vacatur for trafficking victims, and I will right now, because of the unique circumstance that some people found themselves in when they actually did take a criminal conviction. And I'm okay with reviewing that process for that. So I'm okay with saying that for myself. As for an organization as representing the MPA, I'm not in a position to vote today, but I can tell you that this is something from a personal standpoint, I think that we can and should explore as a state.
All right, thank you. And Michael.
Thank you, Jonathan, for that reminder. And just as a final point, to reiterate something that has been said multiple times, if we support this motion, it will not create an expungement law. It will not make expungement available. It won't set an expungement process in motion. It will just give the legislature some more confidence that whatever expungement laws they may consider in the future won't be invalidated as unconstitutional or as in violation of State versus Hunter. Dee Clark, who, if she didn't pass away, would be part of this group, dedicated her life to what DA Sarabek just mentioned, which is allowing for expungement for women who've been trafficked and have been forced to commit crimes as a result of that kind of trafficking. And that is not a form of relief that Maine can give right now. Other states can, Maine can't. If we support this motion, it would bring Maine to the place where it can give that kind of relief to survivors of human trafficking, for example. And so I just wanted to remind people of that and thank DA Sarabek.
Thank you. Further discussion? So is everyone clear on the motion? Oh, Judy, you raised your hand. Go ahead.
Yes, thank you. So the motion before us, it is not layered with this prior discussion when it goes to judiciary. It will go bare as just that single sentence.
Correct. Yes. And Do committee members need Peggy or Jane to read back the motion? Would that be helpful before we vote? Why don't you go ahead and do that? Peggy or Jane, whoever has it, could you just read back the motion? Or put it on the screen, even better. Thank you.
Sure.
So the motion is to ask the Judiciary Committee to review options and report out legislation to address the separation of powers questions raised in Hunter. So that is what we are voting on. Thank you, Peggy. And is the committee ready for the vote? And Peggy or Jane, what is easier for you? Is it easier to do a roll call probably with so many people? All right. Jane, are you going to do that?
I'm ready.
All right. Thank you.
Senator Bailey.
Yes.
Representative Talbot Ross.
Yes.
Representative Pickett.
Yes.
Representative Harnett.
Yes.
Foster Bates.
Yes.
He doesn't control the audio.
Yeah, Foster, yes. I heard you say yes. Okay. Samantha Hogan.
No.
Peter Lehman.
Yes.
Andrea Mancuso.
Yes.
Barbara Taylor.
Yes.
Marissa Bodnar.
No.
Emma Hallis O'Connor.
Yes.
Michael Cabeda.
Yes.
Hannah Longley.
I abstain from the vote.
I'm sorry, I couldn't hear you.
I have to abstain from the vote. I'm sorry.
Abstain. Okay. Thank you. I'm sorry to have to ask you again. Judy Meyer.
A reluctant yes.
Elizabeth Ward Saxel.
Yes.
Jill Ward.
Yes.
Laura Ustak.
Abstain.
John Feeney.
That's
John.
No.
Okay, thank you. Matt Ruel.
No.
Scott Landry, not here, right? Okay, Matthew Morgan.
Yes.
Robert Young.
I'm going to abstain.
Okay. Jared Mills.
I will also abstain.
Okay, thank you. Jonathan Sarbeck.
Abstain.
And Judge Davis is not with us right now, right? Okay, that's all. That's 14 in favor. Someone check my math if you did it. 14 in favor, 4 opposed, and 5 abstain.
And how many people were absent, Jane?
Oh, absent is 1, 2, 3, 4.
Okay. And I think we had decided that those people who are absent would have until, was it Wednesday at noon to register their votes with Peggy or Jane? Just so folks know, so the actual tally may change a little bit because they do have that time if they're absent. Well, thank you all for that. Very good discussion. And now we get to move on the second motion that we tabled last time, whether to recommend to the Judiciary Committee that they hold a public hearing on a process for sealing criminal history record information as proposed in LD 1459 with consideration of amendments proposed during the work of the Criminal Records Review Committee. And Michael, I think this was your motion. Did you want to, excuse me, did you want to clarify the language? Is it as I just read it, or is it something different? So if you could just clarify the motion, thank you.
Thank you, Senator Bailey. I think you've captured my motion.
Okay.
I would like to add that I know that Maine Press Association has some amendments they would like to make, and happy to discuss those if they would like to describe them.
Okay. Well, I think first, as Representative Harnett reminded us on his motion, we first need to take yours off the table. So if you'd first like to make that motion to take it off the table, and we'll just take care of that first.
Okay, I move to take my motion off the table.
All right, and do I have a second? Seconded by Representative Harnett. All those in favor of taking the motion off the table, if you could just raise your hand.
Okay.
Okay.
Thank you.
Thank you. It is now off the table, open for discussion. Representative Talbot Ross. Oh,
My apologies, Madam.
Oh, that was left over from before. Sorry. Thank you. So discussions, questions on this motion.
Do we have a second on the motion?
We did from last time.
Okay, okay.
I don't remember who it was, Jane or Peggy. Could you remind me who it was? Or if the person is here, if they could speak up.
I thought it was Representative Harnett, but I'm looking for my notes.
Well,
I believe that's what the notes said.
I think the notes say Courtney Allen.
Courtney Allen. Okay.
This is the motion with regard to 1459. There's a
Correct.
motion by Michael Cabete, seconded by Courtney Allen.
All right.
Thank you.
Thank you. So Representative Pickett.
Yeah, could, I don't have that in front of me right now. I know you went over it, but could we either have it up on the screen for a minute, or could somebody read that again, please?
Sure. It's in your agenda if you have that, but
I don't have it in front of me.
sure. Okay, so I'm sure Peggy or Jane can put it up. So it's B there. Whether to recommend to the Judiciary Committee that they hold a public hearing on a process for sealing criminal history record information as proposed in LD 1459, with consideration of amendments proposed during the work of the Criminal Records Review Committee.
Thank you.
You're welcome. Further discussions, questions, clarifications? Samantha.
So I just wanted to respond to Michael's offer for us to discuss amendments. I just wanted to know what the committee is thinking about whether we are looking at actual language changes to 1459 and whether that's a discussion that wants to be had, or if the intent was just to send the rubric to the Judiciary Committee. I'm just looking for some guidance.
Yeah, I mean, I think the intent by this motion is just to send the rubric, and I think we talked about, you know, we had the chart and the comparison and with comments and notes. And that's the part talking about consideration of amendments proposed during the work of the Criminal Records Review Committee. But that's my understanding. If the committee wants to go in a different direction, that's fine. But my understanding is no, just to recommend Judiciary Committee take up 1459. When you take up 1459, look at the work we did and the comments we received and some possible amendments to that. Elizabeth?
Yeah, I may be missing something, but I thought 1459 was carried over into this session, and so we'll be going to the committee for public hearing. And so I had thought that the motion was going to be to consider issuing the support of this group for that.
So 14.
Proposed legislation. What am I missing?
Peggy's going to correct me if I'm wrong, and I might be, but my recollection was 1459 was not carried over, but the Judiciary Committee did carry over another bill that could be used as a vehicle for, anything, but including 1459, and I forget the number. It was 13 something. Peggy, what's the number? 1310. Thank you.
Yes. So I don't want to, you don't have to use, this study committee does not have to use LD 1310, rely on 1310. You have the ability to recommend anything to the Judiciary Committee. The Judiciary Committee under Joint Rule 353 has the ability to report out a bill. The Judiciary Committee has 1310 to use to put anything else into legislation before the second regular session that doesn't fit into that one bill. And there's always the opportunity for the committee to ask for a joint order to report out more legislation.
Thank you. I'm sorry to be behind the ball on this.
No problem. Barbara?
And just to clarify, this group will not be recommending any additional amendments to 1459, is that correct?
As of right now, the motion is what it is. I know that Samantha kind of tossed that out for consideration, and I'm not hearing anyone, insisting on that, but we're not done our discussion yet, I guess is the answer. All right. Representative Talbot Ross.
Thank you. I'm just wondering, for those who are not, inside, the State House, if really all of the vehicles, the pathways are as well understood as they need to be. Because even as a legislator, it's very hard to understand if you carried over a bill to be used as a vehicle, why you're not using that vehicle and you go some other route. Those things are really politics, not policy, as far as I'm concerned. It all depends on who moves certain materials around. It's like a chessboard. And I'm just putting it out there, as a person who's been working on criminal history records for 5 years, it's not that easy. And so if it carried over 1310 for a vehicle, and then, or the committee could ask the judiciary to do, it just feels like a colossal waste of time if we don't agree on what it is we're moving forward. And then look at what we have available to us, put it in there. If it's not enough, but it's a real insider's game conversation. And it may not be fair to the public and or folks who are on this, participating in this committee, who don't get that set of, that game. Just for the record.
Thank you. Judy?
So just to reiterate from the last meeting, I don't feel like we've worked this nearly to the degree that it's ready for a public hearing. We haven't even gone through the rubric line by line. We haven't talked about the inequity of not providing a lawyer to a low-income person who may want to file a motion to seal. The way 1459 is proposed, it is set up so that people who can afford lawyers can move forward. I think we need to talk about that. This is a significant hurdle for people. I also have a grave concern that we're not considering the comments and the recommendations of Justice Alexander, because what we're doing is changing the status of records produced in judiciary. And to dismiss his concerns and not even to consider or even discuss his recommendations, to me, I would feel irresponsible if we moved forward without doing that. And we have spent, collectively, all of us, with meetings, the pre-homework, all of the stuff that we've been doing, hundreds of hours discussing these topics and haven't looked at the rubric. I cannot move forward until we do that. I also have a really large, maybe my largest concern is that the governor has already signaled through her letter to us that she would like to see the employment legislation, move out for a year before we make any global changes. And since whatever we decide to do, whatever recommendation we make, even if it's just to a public hearing and goes to judiciary, it will ultimately go to her desk. And she has signaled to us in very clear language she's not supportive. So I think we have a lot of work to do to get to a place where this could be supportive. And just as a point of information, I'm representing the Maine Freedom of Information Coalition on this committee. I do see a way forward to seal some records, some scope, some method, but not as proposed in 1459. So I will oppose this motion until we can do more work.
Thank you, Judy. And I mean, you are right that we haven't gone through the rubric. I think we talked about that last meeting, is that, we just don't have the time. And so what this motion is essentially saying is, Judiciary Committee, go through this rubric line by line and do the deep dive. So just to clarify that. Michael?
Thank you. I believe Barbara Taylor's hand might have been up before mine.
I think that's left over from before. Barbara, is that correct?
Okay, it appears to be so. So we have an hour and 15 minutes left in our, time together. Unfortunately, sad as that is, I hope we're back together again in the future. But this bill was scheduled for a public hearing. The Judiciary Committee at the legislature already decided to give it a public hearing in the spring, but because of the pandemic, it didn't get that public hearing. This bill also just expands an already existing law. It's not an unprecedented thing. It's not an unprecedented way of giving some people relief from the shackles of a criminal record. The governor has the option to veto bills that the governor's office disagrees with. I mean, the way I understand the legislative process is, both chambers pass a bill, goes to the desk of the governor. If the governor doesn't like it, governor vetoes it, then it goes back for possibly a veto override. If it fails, it fails. And I think every legislator who proposes a bill knows that, and knows that that is a possibility for their bill. Their bills often get vetoed. And so the way I understand the process to work isn't, if the governor likes it, then it gets to go through the legislative process. If the governor doesn't like it, it doesn't go through the legislative process. I mean, that seems like it kind of short circuits the process that we have for a letter from the governor's office to even prevent a bill from getting a public hearing. That's not how I understand the process to work. And finally, many hours went into this process, but many hours went into that bill. And the reason I made this motion is to honor those many hours. And I understand that there are some people here who weren't fully a part of the earlier process. And I think that during the legislative process that this bill goes through, those groups can get a fair hearing. And we'll continue to discuss what the best option is for incorporating every stakeholder's concern. And so, I do think that the bill deserves a hearing. I think a lot of the concerns of stakeholders were addressed in the bill. It took many, many, many hours to get it together. And I personally, and the ACLU, is absolutely committed with working with freedom of access and freedom of information advocates and with the press to address their concerns in the final version of the bill.
Thank you, Michael. Yeah, I would like to see a public hearing so that all voices could be heard. And I'm cognizant of the fact that, you know, I don't know what the Judiciary Committee is going to do after that public hearing, after its work sessions. You know, they may vote on a bill, they may not. You know, they may in fact say, okay, we've had a public hearing, we've gotten input, and oh, by the way, we reconstituted the CRRC, and now we're going to kick it back to them and keep the process going. There's lots of options of what the Judiciary Committee may do, but I think that it's important to keep the process going, and in particular to give an opportunity for the public and all sides to have an opportunity to weigh in, which I don't feel that, you know, this committee was set up to do. So those are my thoughts. Samantha.
So recognizing that a lot of hours and consensus was found in previous iterations of the Criminal Records Review Committee, completely acknowledge that. The Maine Press Association did not previously have a seat on that. Our biggest concern has been the legality of being able to continue to publish truthful, newsworthy information. Would it be a friendly amendment to specifically add in some of the language that we've proposed into LD 1459 at this time? I don't know if we could entertain a separate motion to amend that bill to include some of the language that we've proposed, specifically addressing that concern, just because we did not previously have an opportunity to be a stakeholder in that. Obviously, there continues to be a time for us during the public hearings to also make this recommendation, but understanding that we are a stakeholder in this bill, we would like to potentially move forward with the proposed amendments.
Yeah, I think as far as friendly amendments, that would be up to the movement, Michael. So we'll get his input on that. As far as the other process and consideration of the amendments, I think there's a couple ways to do that. Certainly, if you did not vote for the motion and you wanted to put forward in the report a minority blurb, if you will, I think the committee could certainly entertain that, and I would not be opposed to that. We also could, if time allowed, perhaps have some discussion about some of your amendments, so that there are ways we can do that. Okay, so I'm going to go to Representative Pickett, and then Michael, you can respond to whether you would be willing to entertain any friendly amendments to your motion. Representative Pickett.
Yes, thank you, Madam Chair. If we were able to look down the corridor of time and be 100% sure that LR 2503 was going to keep this committee moving forward, I think it would be a great idea to wait and to go through that line by line by line and make those final recommendations into the Judiciary Committee on what we'd like to see on this. But we have no way of knowing whether that's going to happen or not. So therefore, because of that and all the hard work that was done on this review committee before I was part of it and what's been done on it this time, it's kind of too bad to just not see it make it into the committee and get a public hearing on it, and then see where it goes from there. And hopefully LR 2503 will go through and we'll get a chance, and possibly it will be thrown back to us to be able to fine tune it and do what needs to be done with it, if whatever the position might be. But that's why I will be supporting the motion.
Thank you. And Michael, your response to Samantha in terms of entertaining any friendly amendments.
So as I understand it, the amendments are threefold. Number one, it would exempt news organizations from criminal liability for sharing information that was lawfully obtained, right? And then number two, it allows the press to petition the court to review records of a conviction that have been sealed. Just creates a petition process. And then number three, actually, there is no number three. It's just the petition process and exempting press associations from criminal liability for sharing information that was lawfully obtained, right?
There's two separate sections about publishing. So one, the first that you referred to, George Freeman brought up about the offense section of publishing things that are confidential criminal records, which I believe is a misdemeanor charge in Maine. And then there is a special restrictions section separate in a separate statute, which, yes, we were asking that there be a ability for the press and public in general, any member of the public, to be able to petition to see sealed records, and then also to again reaffirm that it's under the special restrictions, that it's not a violation of that statute to publish information about a sealed conviction that's already in the public domain or lawfully obtained.
So Samantha, I think what would be helpful to me and perhaps to Michael is that was a lot of information that you need to be really clear as to what is the friendly amendment that you want Michael to consider.
Yeah, so this document was shared on Monday immediately after the last meeting. It's called Maine Press Association Proposed Language Amendments, and we listed the specific sections that this would appear under. So I don't know if people can look in their emails. Jane did send that out. I don't know if Jane or Peggy could pull it up, but it does, and it has the reference sections in it.
Well, and again, it sounds like you're talking about, and if I remember reading it, you were talking about changes to 1459.
Correct.
Which again, this motion is not, we're not specifying exactly what parts of 1459, and we're saying consider amendment. So again, the current motion is whether to recommend to the Judiciary Committee that they hold a public hearing on a process for sealing criminal history record information as proposed in LD 1459 with consideration of amendments proposed during the work of the Criminal Records Review Committee, which those amendments would include the ones from Maine Press Association. So what amendment are you looking for to that pending motion for Michael to consider?
I think what we were actually hoping was that 1459 would be amended to include those. If that is not able to be accomplished through the pending motion, I think your idea of doing a minority report specifically describing why we voted against this motion might be appropriate.
Okay, yeah, I mean, I think it's more a question of process, because we're recommending that the Judiciary Committee take up 1459, and that as part of that public hearing process in Judiciary Committee, that they consider amendments to 1459 that were discussed here in our committee. But we're not getting any more specific beyond that. And I think you want to be more specific in terms of specific amendments to 1459. And we just don't have time to go down that path to list all the amendments we favor and the ones we don't. That's why I think we were saying just send it back to Judiciary Committee to consider all those and look at them, which again, the ones from the Maine Press Association are included in those amendments. and anyone correct me if I'm wrong, but they are included there. We're just not listing out certain ones specifically or not. But Michael, do you understand now what Samantha is asking you for in terms of a friendly amendment?
Yeah, I believe so. I think that you're right, Senator Bailey, that the motion as crafted includes Maine Press Association's amendments. And I think to add Maine Press Association's amendments more explicitly within the motion creates kind of an unfair hierarchy of amendments. I mean, there are other amendments, there are these amendments. I think it would be fair for judiciary to consider them all at the same time. If we had more than an hour to go, then I think it would be good for us to do a deep dive on all the amendments of Maine Press Association. But I think that in the Judiciary Committee, that time will come, and you'll find a sympathetic partner in the organization I work for when the time comes. So I do think the amendment as written, or rather the motion as written, captures the Maine Press Association amendments, since they're part of the Criminal Record Review Committee's work.
Thank you. Peter, did you have a question, comment?
Well, I just wanted to say that that I intend to vote for this motion, despite the fact that testimony at the Judiciary Committee, testimony on 1459 would definitely be neither for nor against, because I believe that there are major changes that need to be made in it. I nonetheless think that it's tremendously important for us to get this on the floor and to have this conversation in the Judiciary Committee. I'm absolutely convinced that the more conversation we have in the legislature about these issues, the greater understanding there'll be among legislators of not only the benefits but the traps involved. And so I just really wanted to say that I'm not voting for 1459. I'm voting for it being considered by Judiciary Committee and have a public hearing.
Thank you. Further discussion? And is everyone clear on the motion? I did just read it again. Can you just like shake your head if everyone's okay? All right, thank you. So I think we are ready, Jane.
Okay, thank you. So the vote on it's a motion to recommend, and you heard it, on a public hearing and consideration of amendments proposed during the work of this committee. Senator Bailey, how do you vote?
Yes.
Representative Talbot Ross.
Yes.
Representative Pickett.
Yes.
Representative Harnett.
Yes.
Courtney Allen is absent. Foster Bates.
Yes.
Frank D'Alessandro, absent. Samantha Hogan.
No.
Peter Lehman.
Yes.
Andrea Mancuso. Is Andrea with us? Okay. Barbara Taylor.
Yes.
Marissa Bodnar.
Yes.
Emma Hallis O'Connor.
Yes.
Michael Cabeda.
Yes.
Hannah Longley.
Yes.
Judith Meyer.
No.
Elizabeth Ward Saxel.
Yes.
Jill Ward.
Yes.
Laura Ustak.
Abstain.
John Feeney.
Abstain.
Matthew Ruel.
Abstain.
Scott Landry is absent. Matthew Morgan.
Yes.
Robert Young,
Abstain.
Jared Mills,
Abstain.
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 Judge Dave, pardon me? Judge Davis, Jonathan Sarbeck.
Abstain.
Okay. So I have 1, 2, 14 in favor. 6 abstain. 2 no. And 7 absent. Is that, does the math work?
Peggy is
No.
shaking her head. Oh, no.
No, I got 1 too many. Oh, 6 absent.
All right.
Thank you.
Thank you, Jane. And again, those who are absent will have until Wednesday at noon to register their votes with Peggy or Jane. So thank you all. Good work. Is there any other business we need to take up before we finally adjourn? Judy?
When would you need minority reports to get into the report to make time?
Yeah. Peggy or Jane, would you like to answer that since that burden is really on you?
I'll turn that over to Peggy.
We really, you know, our reporting deadline is Wednesday. If you could get it to us by Wednesday. As you know, the majority isn't including legislative language. So you wouldn't have to do that. You can just state your position. Or if you have language you want to consider, like what Samantha has already offered for language, you could do that if you want to. So can we say Wednesday at noon? Does that make sense, Jane?
Sure.
Okay, thank you.
And Peggy or Jane, could you just share with the committee kind of the process from here for those who may not have been involved in these type of committees before?
Well, we do have, we sent out to you a draft report, and we'd be happy to get feedback from you, and particularly corrections. Anything that you think needs to be done to put that into shape. It was, of course, written before this meeting, so it will need to be updated. We will we'll certainly make any corrections. Peggy and I have also already spotted a couple of typos. We'll make those changes. If there are any changes in the report that are substantive, we will need those changes, corrections to be made by the chairs. We don't have the authority to make those substantive changes. If I would say if you could get us any work other than the minority report, which would be a Wednesday noon deadline, if you could get us any of your other comments and corrections by the end of the day on Tuesday, that'll give us Wednesday morning to try to get that into shape for review by the chairs. So then the report will need the chair's approval when it's finished, and it also gets reviewed in our office, and you'll be the first to know when it's ready to be released. Peggy, anything else?
Yeah, I was just going to say that we are happy to work with whoever's putting together the minority report. We're not saying you have to draft it all. If you can just let us know what you want, and if you can, actually say that in the meeting, that makes it easier for everybody to understand. But we're happy to work with you to actually put it on paper.
Okay. Any other questions or comments about the process going forward? Such a quiet group after those two lively discussions. Well, not seeing anything further, I would like to extend my thanks to all the committee members for your active and insightful participation. I have learned a tremendous amount and always open to learning more, but your contributions were very much appreciated. And so thank you for your service and your time that you've put into this. I want to thank our analysts, Jane Overton and Peggy Wrench, for doing such an incredible job keeping us on task and writing this beautiful report that's going to be coming out. And yeah, so thank you very much. And I do hope that we are reconstituted and we can continue our work. Chair Talbot Ross, did you have some parting remarks?
Sure. Thank you, Madam Chair. Just wanted to echo what you've already said. I would add that I want to express my sincere appreciation to the Maine Department of Corrections that have allowed for Foster Bates, who is the president of the NAACP Maine State Prison Branch, to be able to actively participate. It changes the dynamic of this discussion when those who are currently struggling within a system who are most impacted have an equal seat at the table and can help make decisions. So I just want to thank the Maine Department of Corrections and to Mr. Bates himself for participating. I also just want to thank the listening public. This is a really confusing amount of material, a lot of material that we just went through. And while it is posted and shared on our website, on the webpage, I would encourage any member of the public who's interested in weighing in to pay attention to sign up for the interested parties list for the Judiciary Committee, so you can be informed in a timely manner as to when more discussion will take place within that within that body. So thank you, Madam Chair. Thank you to the staff, amazing, brilliant staff, and thanks to each member who really showed up. We were worried about the number of people on this committee, and it looks like it actually works for us to ensure that all voices are being heard. So thank you to each and every one of you. Really, really appreciate all the hard work and commitment.
Thank you, Madam Chair. And with that, we are adjourned. Thank you all.
Merry Christmas and a Happy New Year.
Yeah, happy holidays, everyone.